People who know me for a long time know that thanks to my client, I was assigned a slash-riding position on a US patent for an FFT application. And recently I got a lot of questions from one of my followers on Instagram about how these patents protect and how when you have a patent you can share the knowledge with a university, aka a den of thieves, and you can do just about anything else. And I personally believe that the patent is just a small part of a robust IP protection strategy, and in the following steps I will be giving you my point of view at the topic. And before we get into the detail and start to wash the dirty laundry behind me, I of course have to make a legal disclaimer. You see, I'm what an American would call an armchair attorney. I've never formally studied law, only for like half a semester at an engineering school. And what I know about law, I know from my own quarrels and my own work for consulting clients. But once again, I'm not a lawyer. This video is not legal advice. Anything that I'm saying you can be wrong, might be wrong. It is just my musings. And I of course take no responsibility whatsoever. And now it's time to get started. And before we get into the topic, I just wanted to say thank you to my client. Once again, if anybody of you is looking for a thinking ashtray which reacts to music, and yes, the colors can be chosen with a phone app, this is the product to test. Currently, it is still not available for sale, but if you email us, we are willing to sell you a prototype unit. Before we go into more detail, we will look here at the life cycle of a US patent. Here in the first step, we have the firm. The firm submits a patent idea to the USPTO or to the Austrian Government Patent Office or whatever. And they have a gaggle of examiners. And these examiners, usually while they are engineers, of course they are not industry specialists, and they perform mainly a formal check, and then they will either reject or they will grant the patent. And yes, of course, this formal check will find egregious problems and also, for example, egregious violations. So if I copy a patent from a friend and submit the same text again, probably the examiner will find it. But the problem is, of course, this examiner is not a subject matter expert at the level of detail which the submitting firm is. And by definition, he cannot know all prior art. And so it is very realistic and very possible that you get a patent and there is something which is wrong with the patent, or there is a hair or something in the ointment. When we are talking about examiners, I have to tell you patentbots.com. This website is candy when you are working with the USPTO, because you can enter the name of any random examiner. This is just a random guy I found on Google. And then you see here, it tells you the difficulty ranking. So you can very easily show, is that guy more difficult or is that guy more easy? And you also see here, of course, where he lives, his private email address, and some other informations which might make communicating with the person easier. And now here, of course, we have the patent. And let's now assume that somebody infringes on the patent. And then what happens in the next case is basically a court case, a civil court case starts. And in the civil court case, not only are there significant fees, but in many cases, this is the first time where an actual detailed check is done. Because usually the enemy patent attorney will of course try to find prior art. Any kind of prior art he can find, he will find, and he will throw it at you in order to accelerate the process in the court. And this court is also a unique problem for some other reasons, for which we will need another diagram. And of course, there is also another candy problem, namely how to find out about an infringement. This is a really big problem because basically you never know what is inside the product. And in many cases, it is very difficult to find out. And you can have a competitor here who is making hundreds or thousands of dollars in a very small market, and you don't even know that he's infringing on your patent. And this is something which we also will have to look at in some detail in the next step when we talk about the IP strategy as a whole. And here we have the court, and the court is a hell of its own, because we've got, first of all, the judge risk. In the end, you never know how the judge will decide. Secondarily, the time risk. Cases can take years. And third, something for which there is not a good English word. I prefer the Austrian term, which is a Prozesskostenrisiko. This means the costs of the lawsuit. Lawsuits can be notoriously expensive. I'm currently fighting my co-owner over a coffee shop. The coffee shop is worth like 25,000–30,000 euros. I've got more than 17,000 euros in legal fees. And this is in Central Europe, where the legal fees are very cheap, like 100–150 euros the hour. In the US, the guy, alone your lawyer, charges you 500 bucks the hour. And in many cases, the risk of losing the case, the cost is so high that your financial people say, no, even though we know we win it, we have to kill it because we are going to face starvation long before we get a decision. And especially risky it is if you are dealing with a very well-capitalized enemy, because a very well-capitalized enemy can just go into an appeal and waste your time basically until you go bankrupt. And yes, for completeness' sake, we also have to remark a special case here. The existence of a Prozesskostenfinanzierer. This is a company which joins into a lawsuit and finances the lawsuit, but in exchange, often they either want a specific outcome or they want a share of the profit. A good example for this would be Peter Thiel in the Gawker lawsuit, where basically Peter Thiel financed the lawsuit against Gawker, but of course he who pays the piper sets the tune, and they selected for a very specific outcome. And the moment you bring in a Prozesskostenfinanzierer, basically you are no longer the pilot of your own aeroplane. And what is really important here is also that these Prozesskostenfinanzierers are not interested in every case. And it can be notoriously difficult to find one of them which is interested in your specific situation. So I'm only mentioning this as an addendum that you know that it exists, but don't hope you get it. And now that we've looked at the problem, it's time to look at the solution. And the best example from my point of view is this thing here. This is a Thermomix, or as some people prefer to call it, a Thermovix. This is basically a food processor with an integrated scale and an integrated heating element. And it is really technically not difficult, but it is very simple to use, and basically everybody, man or woman, who cannot cook but wants to pretend that he can cook, buys a Thermomix. And the success of the Thermomix and of the Vorwerkus company is mainly based on their intellectual property strategy. And in fact, they openly admit this. And so, while we are of course not going to talk about the Thermomix strategy, we can take a few inspirations here. And yes, at this point, also my video on the Javelinus, which is here, and the second video on the Javelinus, which is coming when I have the time to make it. You should also keep these in mind, because solving this kind of problem requires, like a cogwheel, many gears to fit together. To start with the most important law of patents. The moment you patent something, it becomes public knowledge. And basically you disclose it, and in exchange for that you get the right to protect it. But in many cases, keeping stuff secret is much better, which brings us back to the Sidewinder problem from the Javelinus video. If the Sidewinder would have never been stuck in the Mikoyan Gurevich, then the Soviets would have never had a Sidewinder. And incidentally, on the F-14, on the swivel wing, on the Tomkato, they had a lot of avionics inside, but the developers were not allowed to patent it. And a second, incidentally, funny thing is that there were a lot of Soviet publications making fun of the American patent system, because they were basically saying the Americans are giving us their most advanced information on a silver platter. So secrecy is of course one thing you need to keep in mind. You don't need to patent everything. Sometimes a bit of information is better kept confidential. And yes, the Javelinus 2 video, which I hope to have finished in a week or two, so please like and subscribe, will look at more detail about how to protect technically your IP, even though we won't be speaking about the Javelinus, because otherwise we get no advertising revenue. And of course, the second thing which we need to keep in mind is technical nastiness. Especially if you have a connected product, such as this thing here, where you see we can change the colors of our ashtray. It would be just so nice and so terrible if an infringing product sometimes crashes, or the app sometimes crashes, or we live in the age of the in-app purchase. So maybe the app could erect the parasitic hand if it detects a counterfeit product, and could be like, give me some money. So this is the next thing. You can do a lot of technical magic. And yes, of course, you can also, especially against firmware cloners, you can put in secret features in the firmware which make detecting your own product significantly easier. And of course, another bit of strategy, which is very useful, involves making an ecosystem play. For example, in the case of such a product, for a customer who wants to clone it, who buys all the parts off of a random distributor, okay, he can use OEM secrets to save some money. But we, for example, use unique custom light emitting diodes, which are made to our specific demands. And so there is a value of working together with us, which the client just does not have if he does not work together with us. And before we end this, I wanted to give you an advice, especially if you can speak German. The people at Vorwerk and their attorneys are very, very talkative about their strategy. And this search string, especially if you can speak German, provides a lot of documents which basically tell you what Vorwerk does, and then you can just copy from them. And with that, I hope that I have been able to be of some use for you. If you have liked, as always, comment, like and subscribe, and see you around soon for more content. Thank you so much.